Right, good morning ladies and gentlemen. Welcome to this, the 21st meeting in 2013 of the Economy, Energy and Tourism Committee. Can I welcome all members and witnesses and those in the public gallery. Can I remind everyone please to turn off or at least turn to silent their mobile phones and other electrical devices. We have apologies this morning from David Torrance. Item 1 on the agenda is continuation of our scrutiny at stage 1 of the Regulatory Reform Scotland Bill, and we have two panels of witnesses. Our first panel are with us this morning. I'd like to welcome and introduce, starting on my left, Aidan Smith, who's Head of Planning and Development at the Royal Society for the Protection of Birds Scotland. We have Francis McCleary, who is with the Law Society of Scotland, and we have Richard Escott, Head of Offshore Developments at Scottish and Southern Energy. Thank you all for coming. You've all given us written evidence. I'd propose just to go straight into questioning. There's a number of areas, I think, of interest to members. We want to look at marine licence applications and the appeals process around that. I think members are interested in provisions in the bill in terms of the duty on regulators to promote sustainable economic growth, and also looking at issues around the proposed changing to the planning fees system that's in the bill. So we'll cover these points. I would ask members if they would to direct their questions to particular individuals, given there's three quite disparate interests represented on the panel. And if you want to answer a question that's directed to someone else, please just catch my eye. And then if there's other points you're anxious to make, catch my eye and I'll just bring you in as time allows. Right, I think we'll start on the marine licensing and I'll bring in Dennis Robertson.
Thank you, Convener. My question will be directed to Richard. Good morning, panel. We've read your written evidence with regard to your view on marine licensing and the appeals process. I'm just wondering if you could maybe elaborate it for the committee this morning. You seem to be taking a view that perhaps there maybe shouldn't be an appeals process?
I think the position that we're trying to put across is not that there shouldn't be an appeals process. It's more we're keen that any process that we go through in a consenting and development perspective, we've got clarity of what's going to happen from an end to end. We're currently caught within the Section 36 of the Electricity Act provides an opportunity for ultimate judicial review at the end of a consent being granted for one of our offshore energy developments. Throughout the process that we go through as in consenting, there's lots of opportunity for consultation and response through that. There's also the gathering of evidence from the statutory consultees as well. So there's many opportunities for individuals and organisations to put forward their views, which have to be taken into consideration as part of the ultimate application for the energy consent. When we get to the end of that process, in the event that there is dissatisfaction with the process that has been gone through, there is the ability for a judicial review against that decision being made. And we're comfortable with that as a process. What we're uncomfortable with is the thought that there is perhaps a second or a parallel process that can run alongside that, so that if we have an appeals process within marine licensing as well, which runs to a different timescale, we could end up in a situation that you have two different appeals going on simultaneously to slightly different timescales about slightly different points. And it just adds an additional level of uncertainty to us about when we get to the end of the journey of trying to get a consent, which takes several years in the offshore environment, how much uncertainty still remains there before we then try and look to invest significantly in the next phases of the project.
So do you see that as a potential obstacle or obstruction into future investment?
We do. We see this as an additional hurdle that potentially has to be crossed, but it's more around whether it's about how we plan for the eventuality, and also what would happen if we did have simultaneous appeals running at the same time. So wholeheartedly support the concept that if a decision is being made and through that process that we've gone through, if at some point an error has been made, then there should be an opportunity for that to be addressed. What we don't want to do is have different ways of that being addressed. So if there was a single appeals process that covered the entire consenting process, then that would be fine. Our concern is that this potentially adds in two pathways.
The solution is a single process rather than a paralleled one, which you're alluding to at the moment.
Correct, yeah.
Yeah, okay. RSPB got a view on?
Yeah, in some ways, I guess our view is similar. We're certainly after clarity and certainty on this. Actually, the situation that's kind of arisen here is illustrative of some of the difficulties we face with appeals processes generally. So. We've long advocated that there should be a general review of appeals across the piece, looking at other sectors as well, and that there would be real benefits of having some sort of more general environmental tribunal system or environmental court system which could pick up on all these different appeals, and that could be developed as part of a more comprehensive review of appeals generally, because we've got a set of different appeal systems which have evolved in isolation almost, and that leads to a lot of uncertainty and a lot of difficulty and a lot of extra expense often when individuals or organisations are looking to challenge decisions. So I think whilst we see the need to sort out any uncertainty around marine licensing at the moment in the short term, in the medium term at least, we need to move forward to looking at a more comprehensive review of appeals more generally. Just on the specific proposals for marine licensing appeals, there's a few interesting things that we've picked up on the specifics of the bill. One thing we've noticed is that the proposed appeal applies to an aggrieved person, which is obviously broader than just the applicant. So that's welcome from our perspective, because I think we would view that would potentially allow organisations such as ourselves to get engaged. So that's good. But one of the other things we've picked up on is that the time period for appeals is restricted to 6 weeks, which is very short. I mean, that would be very difficult for an organisation such as RSPB to get engaged with and get lawyers appointed and so on within a period of 6 weeks if we did want to ever get involved in a challenge. But I would imagine that for if an individual ever wanted to, or a small business ever wanted to get involved in challenging a decision, that would become very, very difficult indeed to get organised within that very, very short timescale. So we've got some specific concerns about that element of it, but our general overarching point really is that we could really do with looking at appeal systems across the piece in general, including marine licensing appeals, but also other appeals.
The point that Richard was making is the due process before you get to an appeal stage is a long, protracted one. So I would assume that organisations like RSPB would have been gearing themselves up prior to that. So in fact, you would be prepared. So would the time 6 weeks not be a reasonable timescale?
Sure. So certainly, as far as our RSPB is concerned, I would hope we would be. And in fact, in terms of the offshore renewables developments that we've got, we've been engaged in a great deal of detail with every individual proposal that's come forward. And in fact, I was meeting with some of Richard's colleagues yesterday in Perth to have a general catch up on a number of different cases. So we certainly are engaged from an early stage, but. Of course, sometimes there's a difference in our ability to get engaged, where we, RSPB as an organisation, employs professional staff like myself to carry out these tasks. A small business might not. Local individuals are not necessarily so well equipped to get engaged in these sorts of issues, and they may be issues which we don't necessarily pick up on. So there are broader issues there, I think, than just our interests as well.
Do you have a legal view on this from the Law Society?
Yes, I think it might be helpful to say the Law Society is not arguing for an increase to the 6 week period, but it's important to bear in mind that such a challenge, when this amendment goes through and previously, will only be on a point of law. In a very real way, any challenger only knows whether or not they've got a case when they get the decision in their hand. So they don't really, necessarily won't have warning prior to that point that there might be a need to gear up for a challenge in the Court of Session.
Thank you.
And just on that point, is it your view that 6 weeks is sufficient time then to make a case?
The planning system, for example, is used to a 6 week deadline. It's something that is very familiar. We're not asking for an extension. There are certain things that can be done to improve the process, such as some preliminaries, things known in England as letters before action. These are things that can be used, can be dealt with in the context of the civil justice review. So we're not arguing for a longer period, but I just thought it was important to say that if the committee thinks that a challenger could be thinking about it prior to the time they get the decision, that wouldn't be quite correct.
Bring in Rhoda Grant.
Just on those questions as well. Aidan Smith, you said that you wanted maybe environmental tribunals, but again, we're saying that you agreed with what Richard Escort was saying about judicial review. Are you suggesting another kind of strand in the appeals process, or would judicial review suit your purposes as well and have all kind of appeals under the one framework?
I think the latter. So it would be about simplifying the current appeals landscape, if you like, because there are so many different routes that it's possible to go down for different regimes and different types of development. And I think the difficulties which have come to light around the marine licensing are just illustrative of that, really. So I think there really is justification to look into whether there's scope to simplify the system across the piece and have more of an overlap between these different systems, if you like. So rather than marine licensing developing its own discrete appeal system, and the planning system has its own appeal system, and environmental permitting has its own appeal system, looking at where there's the scope to simplify and clarify that and bring that together so it's a simpler landscape for everybody. And that seems to me to be a real area where we could actually simplify regulation for everybody to benefit businesses and environmental NGOs and individuals.
Okay, thanks. Jake Brody.
So if I may come back to the presentation of the report by RSPB. One of the things that you've talked about is the natural capital upon which our long-term prosperity appeals. I know you'll get questions about economic duty, but where do you see the balance in terms of the recommendation from the bill in terms of development versus economic growth?
Well, so in terms of economic growth, absolutely support economic growth. That's something that we need as an organisation, and our members obviously need to pay for their memberships of RSPB. But of course, it's about trying to do that within environmental limits. So our natural environment has obviously got a limit to how much it can be exploited. So in certain situations, we need to be aware of that and respect that. So it's not economic growth without
Priority, Mr. Smith. In your opinion, is there a priority between growth and development?
I think they all need to be considered collectively, and sustainable development, which is a well-established term and phrase, is something which is set up to take all that into account, to take into account social, economic and environmental factors. So we can, it's possible in some situations to have economic growth and to have improvements to the environment. So, for example, we work quite frequently with developers such as Richard's company when they're putting forward a development proposal and also delivering environmental improvements alongside that. So you get a high-quality development which can deliver economic benefits but can also have benefits for the natural environment as well.
I wonder if I may ask Francis McCreary, we just heard about the tribunals, and the mentions that the Law Reform Committee is considering other important reforming initiatives for the reform of the courts, with the background prospect of a reform to the Scottish tribunal system. How do you see that? Has there been any progress on that? And how do you see that operating in terms of its application to the proposals in the bill?
We're talking about a major project here. It would be, you know, the kind of suggestions we're making would entail a major redesign of the Scottish state, in a way. That's already happening in the context of some administrative law. What we're suggesting is there's certainly a case, as Aidan has alluded, to including environmental decisions in that structure in order to address questions of specialisation and complexity. But we're not making any glib suggestions. We're really putting it forward as a project that should be tackled. But there is some progress. I came across a provision recently enacted which I'm dying to get an opportunity to quote to you. And that was it's in Section 2 of the Scottish Civil Justice Council and Criminal Legal Assistance Act 2013. And in this Act, Parliament tells the Civil Justice Council how it should go about making the rules. And it says, the principles are, the civil justice system should be fair, accessible and efficient. Next, rules relating to practice and procedure should be as clear and easy to understand as possible. Next, practice and procedure should, where appropriate, be similar in all civil courts. And lastly, methods of resolving disputes which do not involve the courts should, where appropriate, be promoted. We'd like these principles to infect environmental procedure, and that would be a major support of the aspirations to have a very straightforward, welcoming Scottish regulatory culture.
Thank you. Chick Brody touched on the question of the new duty on sustainable economic growth, and Alison Johnson has a question on that.
Thank you. I think I'll direct this to Francis McCleary in the first instance, if I may. In the Law Society's submission, you raised concerns about the fact that there's uncertainty over what the phrase actually means, and note that it's unsatisfactory for legislation to impose a legal duty when there's so little clarity as to its meaning, regardless of the intention to provide guidance on the issue. Could you perhaps let us understand what some of your concerns are, what this uncertainty, what issues it may raise?
Forgive me, this may get quite subtle. Professor Andrea Ross of Dundee University has written rather an interesting essay on this. But from my perspective of somebody who's trying to advise a client on what is relevant and what isn't, you begin to immediately encounter problems with sustainable economic growth that you don't encounter with sustainable development. And it's as if sustainable economic growth is a step too far. Sustainable development is less problematic because it's a universally recognised value. It has a root in international law. We have been using it for some time. As I think the SNH said to you, they're not absolutely clear how much difference it would make. I think the underlying point behind that was everybody does have regard to sustainable development. Sustainable economic growth introduces a suggestion towards development, and as if it's adding something in that confuses the balance between sustainable and development. And that's why we're unhappy to have that added into the mix. It will introduce confusion that will make it less clear to advise a client going for a permission, and it will introduce a confusion that will make it less easy for the regulator to take a clear-cut decision.
If I can direct a similar question to Aidan Smith, you certainly RSPB make it quite clear in your written submission that you oppose the introduction of a duty for regulators to contribute to sustainable economic growth, and you certainly seem to favour, or you suggest that placing such a duty on regulators would introduce a bias towards economic growth over other aspects, over the other two pillars of sustainable development, and that you think it would be more sensible to extend a sustainable development duty. Would you like to elaborate on that, please?
Yeah, well, I think in many ways similar to Francis. I guess we're worried as well that it might lead to a bit of confusion for regulators, this duty, because of it hasn't got the same weight of clearly defined definition as sustainable development does. And sustainable development has in itself led to lots of discussions about its meaning over the last few decades, but there are some fairly well understood definitions of it now, where sustainable economic growth is a much newer concept, and although there are some definitions out there, they are not nearly as widely known or as widely understood. So I think adding this into the mix just would be likely to lead to an additional level of confusion for regulators. I mean, certainly our experience of things like existing duties which regulators have. So, for example, SNH have a duty at the moment to balance various different needs, including economic needs of communities and so on when they're coming to decisions. And my practical experience of that is that it can lead to a bit of confusion actually, where there is a bit of tension between different issues. I think the way that the provisions put forward in the bill is quite interesting as well, though. So it applies to a very specific list of regulators which is provided in the bill, and I think it's quite interesting that, for instance, Scottish ministers aren't listed in that list, which I think seems a bit odd, given that they're kind of the ultimate regulator, if you like, in Scotland. And I think the other thing which is a bit unusual about it and a bit unexpected about it as well is its sustainable economic growth is part of Scottish Government's central purpose, and that central purpose in its entirety is something which we're quite supportive of, because it's about encouraging, it's about allowing Scotland to become a more successful country. Absolutely supportive of that, and that's backed up by the National Performance Framework, which includes a range of different indicators as to how Scotland can be more successful, and we're very supportive of the National Performance Framework too. But there's no link in the bill to the National Performance Framework or to that full central purpose. So it kind of seems to be a bit of a halfway house, which is potentially likely to result in more confusion for regulators. But again, it only applies to a very select number of regulators, and not to everybody. So it seems to us to be likely to lead to more confusion than to benefits.
Final question, convener, if I may. Do you think it would be more appropriate then to guide regulators towards the National Performance Framework as a basis on which to regulate?
I think that would be much clearer, because it has got this dashboard of different indicators on it. So they should already, I guess, as part of the government group of agencies and so on, be heading in that direction in any case. But at least that would be more consistent with what's already out there. The way that the sustainable economic growth duty is put into the bill doesn't seem to be consistent with other things which are already out there. I think our preference, though, would be, if anything, to have a duty for sustainable development, and then our next preference, I guess, would be just to keep it simple and not go with that duty at all, just to keep things more straightforward. I think it's likely to result in extra confusion.
Very much. Thank you.
Can I maybe ask Francis McCleary, just on the same point, do you think it would assist if there were a definition of sustainable economic growth?
I'd like to see the definition before I could answer. Possibly. There is guidance, of course, on sustainable development, but it's not a particularly good read from a lawyer's point of view. It's a bit on the one hand, on the other hand, because sustainable development defines a balancing process in deciding in each particular case whether it's a yes or whether it's a no. A similar sort of thing might arise with sustainable economic growth. I think it will. I think it may entail a great deal of debate. My chief concern in that of, I think, other lawyers is it introduces a confusing factor when that isn't really necessary.
Yeah, just on this theme, convener, it seems that we're having this discussion about those two terms, sustainable economic development, that people seem to be quite happy with, sustainable economic growth that they don't, but we're having this discussion in abstract terms. And I wonder if any of the witnesses would care to comment on a practical illustration that helps to make the point. So, for instance, if you know, can you conceive of a situation where a regulator would be confused having to apply the duty of sustainable economic growth, but where they wouldn't be confused if they, by contrast, had to apply a duty of economic development or sustainable economic development? So can you help me by giving some practical examples of where this concern would give rise to problems?
I can suggest something. In the planning system, and indeed in the Electricity Act system, we are accustomed to taking decisions which are entirely spatial in nature. They're all to do with the environment and where something goes and the effect it has on the space it will occupy. When we've moved into wind farms, as we've developed our approach to wind farms, which happens in both of these, the influence of climate change and reaching climate change targets has come in. Now that becomes quite empirical. You want to have facts and figures. And in my experience and in my observation, and I've acted for every kind of participant in these, it's never terribly satisfactory. If you go into the context of sustainable economic growth, you're in grave danger of having an economic passage of evidence which will be terribly interesting but take nobody anywhere. But in order to allow the decision maker to address that question, you might have to listen to all sorts of evidence from professors of economics and you know, I would question the real value of that in a decision-making process. It seems to me to be government's business, that sort of aspect, not the decision makers.
And can you explain to me then how, you know, and I accept the point you're making here that perhaps economic growth shouldn't be considered at all. Can you
Don't understand me, I'm certainly not saying that. What I'm saying is sustainable development already includes the concept of economic growth.
So where's the problem then in just merely restating it? If what you're saying already includes it, what's the problem of just kind of restating it again and perhaps using slightly different words?
Because I think it is a step too far and it skews the balance. But my main concern is that it introduced confusion in the minds of those trying to get a permission in Scotland. You know, what do we have to do? And confusion in the minds of the regulator. It's the confusion that's the problem, less the terminology.
I'm still unclear. You know, the consensus appears to be economic development good, economic growth bad. I'm still really quite unclear here in the difference between the two terms and what it is that makes economic growth objectionable that's not implicit in economic development.
I think you might be making my point for me. Because there is that confusion. I certainly am unclear, and I would imagine that others seeking to use it would be unclear.
It seems to me, though, that, you know, I could say, you know, which part of those three words do people not understand? I think we all understand sustainable. I think we understand, you know, economic, and I think we understand growth. And yet it seems to be giving rise to an undue amount of confusion. I'm almost tempted to think that witnesses are perhaps protesting too much on this point.
Mr. Smith, do you want to?
I was just going to make the point, I guess, that absolutely no objection to economic growth, but in isolation it would be a problem. So economic growth, but taking into account environmental limits and the social impacts of economic growth is what sustainable development is all about. And if sustainable economic growth means the same as sustainable development, then I don't think that is a problem. So if the definition of sustainable economic growth was to be the same as the already clearly established, well debated and fairly well defined definitions that are out there of sustainable development, then I think that wouldn't be a concern to us. But what we don't have is a definition of sustainable economic growth which makes that connection at the moment. So we don't have a definition of sustainable economic growth which is very clear. We do have quite well established definitions of sustainable development.
Well, three members want to come in with supplementaries. First of all, Mark O'Pedge.
Can you envisage scenarios whereby the addition of the duty for sustainable economic growth makes a decision challengeable in court that wouldn't currently be challengeable?
Yes.
Can you go into detail?
The essential principle behind any legal challenge is whether or not the decision maker has had regard to the right legal criteria, has had regard to relevant material. The aspect of sustainable economic growth seems to me to be one of the most debatable pieces of potentially relevant material that I've seen in 25 years of doing this kind of law. So I think one of the things, if you've got a decision that you object to and you're sending it to your lawyers, one of the things you'll look at now is whether sustainable economic growth has been correctly applied. And it's, to my view, highly contestable either way.
What do you think the impact is of the change that has happened in the development of the bill so that it's now sustainable economic growth? I believe the wording is except where it's incompatible with the functions of the regulator to do so.
I think that makes things worse and not better, because as I think the SNH said to you, they already take the criteria of development and the potential benefits that will flow from development into account. Everybody who's taking a decision does. Suddenly now you've got some kind of contest or ranking that has to be introduced. So to my view, given that my problem is about about clarity, I actually think that modification doesn't really help, personally.
And having said that this has an effect on how challengeable the legislation is, can you sketch out a specific example or two of where this could happen?
Well, I think to go back to the example I gave previously, people getting involved in a contested application would have to give additional evidence about economics and economic growth. So I think that's the kind of area, that's where I think it would be a problem. I'm not quite I'm sorry, I don't think I'm perhaps appreciating what your question is.
I'm just trying to, you said that this would make decisions more challengeable or more decisions challengeable. I'm trying to imagine what scenarios would throw up a challenge in court after this had passed that wouldn't throw up a challenge in court before.
The question would be, has the decision maker had sufficient or correct regard or regard at all to economic growth? It just adds a new area of exploration for lawyers.
So what sort of plaintiffs would that be likely to throw up?
I would say either side, because the developer of the proposal will include in that. I mean, I mean, it's quite important to understand the scope of the project of making a major proposal under any of these measures. We're talking about big projects, very, very expensive projects. They'll have to invest in establishing that this does support economic growth. Growth as opposed to just sustainable development, which is inherent to everything they're doing. On the objector's side, they'll have to attack that, possibly on quite fundamental grounds. Very difficult for the decision maker, lots of scope for getting it wrong. Certainly something the lawyers are going to check. I don't think I can take it further than that, theoretical perspective.
Okay. Same subject, Chick Brody.
Yeah, I know, Convener, you want to move on to other matters, but just as my final throw in this semantics. We had a definition from the Royal Environmental Health Institute of Scotland about economic growth, which seems immensely sensible in terms of the continued increase in capacity of an economy to produce goods from one period to another, continuous and sustainable. I, for one, believe that should be the driver, recognising the other factors of social and environmentally sustainable environments as well. But I think, Ms McCleary, you confused me, because I wrote down, you said sustainable economic development includes economic growth. So therefore you must have in your mind what economic growth, sustainable economic growth means.
Well, you have to remember you're asking a lawyer. I have no views on it. I don't know what sustainable economic growth means. I really genuinely don't know.
You and I quote, said sustainable economic development includes economic growth. So you must have some idea of what you're saying there.
Well, I know what sustainable development means. I know what it means internationally, and I know what it means in Scotland, because it's in the Planning Acts and because there's statutory guidance from ministers. But I don't know what sustainable economic growth means. I don't know whether it means something different.
Prepared to consider it and know it as a factor and a characteristic in sustainable economic development.
Sorry, say that again.
I say, well, you say you don't know it, but then you included it in the statement that says you understand it is a characteristic of sustainable economic development. That's your, I wrote it down verbatim.
Yeah.
So you must have some concept.
Well, if you remember, I alluded to the point that was made to you by Scottish Natural Heritage. They're quite clear. They're not, the new duty for them isn't going to make any difference. That's, I'm happy that they should feel that way. I don't agree that that would be the case for everybody else. I think it introduces confusion.
Thank you.
Okay, Rhoda Grant.
Just trying to get some clarity around this issue. You're saying that sustainable development is understood, recognised, defined, everybody knows where they are. Therefore, we need to assume that sustainable economic growth is something different, in that the words in the bill are sustainable economic growth, not sustainable development. So if I'm right in listening to the evidence you've given, what you're saying is we need a definition of what sustainable economic growth is and how it differs from sustainable development and what that duty will mean.
Well, any definition will help address the concern that I have and others have, which is about confusion. So yes, a definition might well help.
Yeah, I think a definition would help as well, but given that sustainable development already encompasses economic development, I wonder whether we need to bother with it, basically.
So therefore, is the panel saying they would be happier with sustainable development recognised term used, because that includes economic growth as part of it, rather than moving on to a new definition of something quite different that we're not very sure about?
Yes, because that would not give rise to the confusion that is the concern.
Just for the sake of completeness, Richard Escott's been sitting very quietly. Does SSE have a view on this?
From SSE's perspective and also from a developer's perspective, what we look for is clarity around the hurdles that we're having to cross. And from an offshore context, which is my area of focus primarily, there is a lot of, we're an industry in its infancy, and we are trying to demonstrate how we satisfy all the existing requirements that we need to do as we go through the consenting process, which is proving exceptionally challenging because science is in its infancy in a lot of areas and research is in its infancy. So we're struggling with a lot of different dynamics here. If there are new tests introduced, provided we know what those tests are, and provided we know what the satisfaction criteria for those are, then we can build that in as part of the process. The challenge becomes, if the rules change as we're going through that process, there are projects that perhaps you wouldn't have encountered or started progressing if you had known test X, Y, and Z was going to be introduced. So I think I agree with the other panellists, and it's down to having clarity on what we're actually being asked to deliver against. And once we know what that clarity is, then we can then aim to satisfy those tests and make sure that everybody knows what the evidence base is for that and what the criteria is that we are going against. We do, as part of the normal development process, there is a lot of, we do look at economic development, we look at sustainable economic development, we also look at economic growth, because within any of our, in particular any of our offshore applications, we may be dealing with multiple local authorities, all of whom are looking for economic development and economic growth within their areas, and we're trying to satisfy and demonstrate how we're going to deliver against that. If it introduced another appeal mechanism or another area for appeal, then that would give us concern. It wouldn't introduce that if we had a clear definition of what we were looking for in the back of that.
Helpful. Right, okay, I think we've given that a pretty good kick of the ball, and we'll move on to another subject of planning fees, and I'll bring in Margaret McDougall.
Thanks, Convener, and good morning, panel.
The bill makes provision for variations in planning fees, and indeed penalises planning authorities where if they're underperforming. ARBI, Aidan Smith and yourself, the Law Society, Francis, have come out and said that they're not in favour of this penalising. Could you perhaps just expand on your reasons for that and your fears around that? And also, Francis, you mentioned in your submission a task force of planners. Could you perhaps explain how you think that would work?
We found ourselves in our discussions in alignment with many other people who had concerns about whether this would really address the problem in an effective way, and that is our fundamental concern. If a planning service in a local authority is failing, if it's not making its targets, if it's doing a poor job, then to strip it of resources is the least helpful, least constructive way of addressing that, it seems to us. There are various, we're talking about planning at a time when there has been huge progress in terms of culture change. The agencies are much tighter in the way they deal with it. All processes have been substantially streamlined. This is happening against a background of diminishing resources. The resources are diminishing because planning authorities don't have so much work, and resources are diminishing because of other concerns on local authorities' revenues. So we've got a very tricky situation anyway. If a planning authority is failing, the first thing that one would want to know is why is it failing? What's wrong with it? And the way to deal with that is not to strip it of resources. The way to deal with that is to send in some help. Mechanisms already exist. There's the improvement service associated with COSLA. The heads of Planning Scotland who are very concerned about how this would intervene with their continuous improvement have various mechanisms which they suggest. Our reference to a task force is more generic than that. It's just if a planning service is failing, it's recognised to be failing, government should send somebody in or a number of people in to sort it out. That's a more constructive thing than removing the resources from it. We feel.
Yeah, our view is very, very similar. I think if a planning authority is already struggling, there's a good chance that it is struggling because of lack of finances in the first place, and so punishing that planning authority financially would seem to be the wrong way to try and deal with that. We're very conscious that planning authorities are effectively almost often at the front line of environmental protection as well. So the decisions they are making are often to protect the environment, and if they are faced with a further financial penalty and are already struggling, what we're concerned about is whether they'll have the continued capacity to carry out these environmental protection roles. So, for example, if there are developments which might impact on internationally designated wildlife sites, so Scotland has an international duty to protect these sites, I'd be concerned if there was any loss in capacity in that planning authority to assess these proposals coming forwards, and if there was, and it did result in problems, then the difficulties would come back at a national level to Scotland. So I think in some ways ministers need to reassure themselves that they're not going to end up creating more work for themselves by carrying out these actions.
Just continue that. What is your view on performance and how you monitor that? You know, an underperforming planning authority, is that one who doesn't meet the timescales for turning around applications? Or, you know, there's the quality aspect. How do you measure that?
Well, I don't know. From my long experience of the planning system, both factors should be present in a well-conducted planning service. You should be able to turn things around quickly and manage your service to that effect, but you should also be sure that your officers are working towards securing quality of place. And if you don't watch out, you know, you can attend to one to the detriment of the other. The trick is being on the ground, making sure your officers are working well, cooperation from developers, which is part of the culture change. And the changes that have happened in the planning system have supported culture change from developers. All of these things go into the mix.
Yeah, so performance is definitely about quality of outcomes rather than number of applications processed in a set time period. That's for sure. It absolutely has to be. Scottish Government have done some quite good work on this, along with Heads of Planning Scotland, to produce the Planning Performance Framework, which I think in theory and in the principle of it we are supportive of. However, the detail of it we're not quite happy with yet, because we don't think it factors in environmental quality and environmental decision making quite enough. It's still quite heavy on the process elements of the planning system. But getting a framework which measures a range of different measures is definitely one of the ways forward. It needs further evolution, but that sort of thing is a better way of measuring planning performance than simply how long it takes to process applications.
Francesco, do you want to say anything from SSE's perspective?
From our perspective, as I say, we interface with a lot of local planning authorities. You have different journeys on different projects as to how around the amount of interaction that you require to get through the process. And the problem we struggle with in a way on some of the projects is, whilst on an offshore perspective you'll be dealing with a local planning authority on the onshore infrastructure that's associated with the development, and then offshore you may be dealing with more than one because of landscape and visual impacts and so on. And they have an ability to logjam the process. If you can't get through the process with them, then you can spend a lot of time trying to get to where you need to go. And within the planning environment, there are timescales that these applications are supposed to progress through, and if you don't get there, then it's within the regulator's gift to move on, but it's unlikely that would ever happen, and we indeed wouldn't support that time, because it would be likely to then trigger a judicial review. So I think from our perspective, we're looking for quality, we're looking for predictability of timing. I understand the thought process around if we need to come up with something that incentivises a planning process to get through that in the right length of time. I'm afraid we don't have a wonderful idea on how to resolve that issue. I do worry that changing the planning fees would end up in resource constraints in the areas that we actually need them to happen. On the other hand, I do believe that we need to continue to move forward on how we increase the quality and the turnaround within that planning process as well. I think it's a difficult one to solve, but I'm not convinced that adjusting planning fees is perhaps the best way of delivering the desired outcome.
Thank you. I just wanted to speak up for processing agreements, which is a non-statutory mechanism which local authorities are gradually coming to terms with, some more quickly than others, which is merely a mechanism to engage the regulator and the developer together in managing the process effectively. And there's a bit of a learning curve still to be dealt with. There's been attempts to make them more complicated than they need to be, but processing agreements and increased use of those is just one of the ways in which you could address a problem.
Thanks, Karina. Maybe directed this towards Aidan. I think you were suggesting that poor performance in terms of planning is perhaps due to either lack of resources, and I'm just wondering if you could clarify it for me just slightly, because surely there's many factors for underperforming rather than just resource constraints, because there's many factors for planning authorities that get it right. It's not just all about resources, surely.
No, indeed, absolutely. Of course, it's not. There are other factors, and often those factors are external from the planning authority as well, because planning authorities are heavily dependent on advice, and heavily dependent on the quality of inputs into the system as well. So in terms of the quality of submissions that developers make and the contentiousness of the applications that they have to deal with and so on. So it is a very difficult thing to measure, which is, I think, why it really needs to be a suite of different measures across the piece, really, to try and make it as even as possible. And even in any 1 year, some of the planning authorities in Scotland are quite small, so a single big contentious planning application in 1 year for a small planning authority can completely skew their results for that year. So these sort of things need to be factored into the measurements of performance.
I agree with Richard that it should be based on incentivisation rather than penalties.
Yes, so absolutely, and I think, though, one of the big incentives for planning authorities is to see how they're performing against their peers, against the other planning authorities. So even just being public, the planning things like the planning performance framework is a big incentive for planning authorities. I just think that the risk of financial penalty, especially if it actually happens, is too big a risk, because it could just exacerbate existing problems.
Yes, thank you. It's really to follow on with this and applies to all of the panel. I mean, incentivisation has its downside as well as its upside in terms of how it's perceived in those that are not performing. I wonder if you care to comment on the following. It's not just lack of resources, the skills and the expertise that you've come up against in your dealings with planning authorities. Secondly, the comments so far underpin the need for not just processing agreements, which I'm aware of and which are progressing but slowly, underpins the need for this reform bill. Also, if you could comment on the consistency of application across councils in Scotland, and also the need for meaningful outcomes in terms of establishing a level of productivity. Because it's all very well saying, well, we're not going to increase or we shouldn't increase the planning fees, but then that sort of takes us into the arena that Francis McCleary was talking about, is we'll send in a task force, let's put some sticking plaster on it and not cure basically cure the problem as quickly as we can. So skills, process and regulatory reform bill, consistency across Scotland, and meaningful outcomes and measurement of true productivity. I wonder if you care to comment on each of these.
I think that my experience with the reform of the planning system since the Act was put in 2006 has been very instructive, because I think that there was a collective recognition that everybody had to work together to improve matters. Planning is an easy target. But I'm not the only one who would question how often a single bad experience or a single vocal complainer, I would question how representative that is. They get a much worse reputation than, in my experience, they usually deserve. That being said, I'm aware that there's been quite a substantial de-skilling of planning departments, particularly recently. A lot of collective memory has been lost, for better or for worse in some councils. I think we've yet to see what the impact of that will be, but I would certainly commend the planning authorities and also the developers that I've encountered, and also the agencies who support the planning system, for their response to the 2006 Act. I think it's not as bad as it's sometimes made out to be.
Smith, Mr. Esco?
I think from the interaction that we have with the various planning departments, there are always, in the same way with planning as there is with all of the other aspects that we deal with, and that includes our own advisors, there is a range of skill that comes out. Some are better than others, and a lot of it comes down to the ability that it's actually a lot of it's down to the openness of the interaction between the developer and the planning authority around, if we are having an issue, how do we address that issue? Is it down to an individual? Is it down, on either side of that relationship? Is it down to the skill?
If there was a quite clear process, an expectation, and defined, what the process is and what the limitations within the bill are, isn't that going to help? And the people, I mean, I'm not saying there should be total rigidity, but currently, in some cases, there appears to be anarchy.
I think clarity of process should always help us as we get through, provided the right resources are in place to actually deliver against those processes. Again, if we understand what the outputs and the quality of that product and the definition of that product actually is, then by defining more closely what it is we're trying to deliver, then we'll get there. I think the issue probably resolves around each of the applications because of the breadth of what the planning departments are now having to look at. The breadth of skill and experience that they need is perhaps so much broader, and there has been a loss of experience from a lot of the planning departments over the last few years, and a lot of the senior guys that have been round the block a few times and have understood have maybe moved on. But on the other hand, because of all the new aspects that are coming in, there's a lot for people to actually learn and try and grapple with the different aspects of applications that they're now having to look at.
Smith?
Yeah. Skills and experience in having enough skills and or the right skills and sufficient experience in planning authorities is a sort of fairly constant concern of ours, I guess, and something we come across fairly regularly when we're advising planning authorities on impacts of developments in their areas. And there's of course a very current example, I think, which has come up, which is in part due to planning authorities not having sufficient resource or sufficient expertise, which is in relation to open cast coal mines, which have collapsed recently, and it transpires that the bonds which were supposed to be in place to facilitate the restoration of these sites, which should have had enough money in them to pay for the restoration of these sites, don't have nearly enough money in them. And I think that is likely to have been because there hasn't been sufficient resource, or resource has been trimmed on the monitoring and enforcement of the conditions and those bonds. So the planning authorities have not become aware of this until we've got into the situation we're in at the moment, where two companies have gone into liquidation. So I think that's quite a clear and unfortunate illustration of what happens when planning authorities aren't quite resourced adequately. In terms of consistency, I think absolutely there should be a certain level of consistency, but there's also inevitably going to be different skill sets in different local planning authority areas because of the nature of them. So the types of planning applications that are dealt with in Edinburgh City Council are quite different from the ones that are dealt with in the Western Isles, for example. So there's always going to be a certain amount of experience and skill in the different areas depending on the nature of the applications that come up. And I think that's where the central support which is provided for planning authorities by the statutory agencies like SEPA and SNH is really important. And I think that's where it's important as well to get a clear steer on things from Scottish ministers too, through things like the Scottish Planning Policy and the National Planning Framework, and that can provide that level of consistency.
And how that might impact that?
In terms which code of practice? Sorry, do you mean in terms of
having the ability to by statute change or give guidance, amendment to the bill?
Sure. Well, in terms of how that's going to impact on planning authorities, I suspect in practice, I think what might be the most useful thing is the planning performance framework, which has been developed already by ministers in association with the heads of Planning Scotland, because that is looking more at what outcomes of the planning process are going to be. And I think that has got potential to be quite a useful tool.
Right, is there no more questions at this point? I think we can call a halt there. Thank you very much for coming and giving your evidence. And we'll have a short suspension to allow a changeover. Okay, if we can reconvene, I'd like to welcome our second panel for our continuing scrutiny of the Regulatory Reform Scotland Bill at Stage 1. We're joined by George Fairgrieve, who's Council Member from the Royal Environmental Health Institute of Scotland, and Bill Adamson, Head of Food Standards, Hygiene and Regulatory Policy at the Food Standards Agency in Scotland. Thank you both for coming along. Before we get into questions, would either of you like to say anything by way of a brief opening statement? Mr Adamson?
Yes, Convener, happy to do so if you would wish. Perhaps just to summarise the written evidence and give the committee in advance of it appearing today. I guess the reason for the interest for my organisation in the proposal is that we do oversee in Scotland the implementation of food hygiene and safety law, which the Street Traders Certificate of Compliance relates to. In that capacity, we provide an oversight of the local authority functions, and on behalf of the ministers, administer the Food Law Code of Practice, which gives some national direction in this area. As I've indicated in my evidence, the proposal, as I see it, is to build on the idea of having one authority who is going to be issuing in the future these certificates of compliance for licensing purposes, which seems to be in accordance with the principles of the Home Authority principle, which is contained within the Food Code as it sits at the moment. And therefore, happy to support that as a proportionate way forward, both in terms of compliance with the code and compliance with general better regulation principles. Probably just worth this saying for the committee that we don't, of course, have the responsibility for the Civic Government Scotland Act itself. That's with Justice and Licensing, but clearly there's an interaction between responsibility and the Scottish Governments in that respect.
Okay, thank you. Mr Fairgrieve, would you like to say something? It's not compulsory.
First of all, can I say that I'm a last-minute stand-in for this. Robert Howe had to go to something else. But apart from that, I think the submission is self-explanatory, so I'll probably leave it at that.
That's grand. Thank you. There are kind of two issues I think we want to explore. The first is the impact on the provisions on mobile food businesses and what impact that will have on food hygiene across Scotland. And the second issue is the broader issue about the new duty to promote sustainable economic growth. So I think in relation to the first issue, a number of members have got questions they want to put, and I'll start with Jake Bruni.
Yes, I wonder, just for clarity, Ms Adamson, I wonder, the FSA is accountable to both Westminster and Scottish Parliaments. Is there any conflict in terms of policy development or management?
Say not specifically, not in relation to this particular issue about street traders, or even in the wider better regulation agenda. We have obligations, as you're right, to both administrations. I don't see any conflict really in relation to the proposals within the bill, and specifically in relation to street traders. As I say, the code of practice, although there's a specific one for Scotland, there is an equally very similar code of practice which applies in the rest of the UK and gives some pretty general direction in the same way. So no, I really don't see any conflict. No.
Fine. I think the written submission was very clear. However, one thing that concerns me is once again we're talking about setting up liaison groups. We have the SFELC, and I don't know what they're supposed to be there to assist you in developing agreed standards. One wonders what on earth is the FSA there for then? I mean, or why are we creating another body, and why are we creating liaison groups? Why can't the FSA do all of this regulation?
Well, I mean, the FSA does indeed oversee the regulation, but there's, well, we do in fact do it in some particular areas. But in relation to delivery, a lot of that is done and has been traditionally done at a local level. And as I've indicated in the evidence, is done by the local authorities on behalf. That's that is something which has been in place and in train for some particular time. The agency's role really is to try and provide a national coordination, I guess, to a certain extent, for that on behalf of ministers, and we do administer the code of practice on their behalf. So we have a role in trying to ensure consistency, proportionality, some of the issues, in fact, which the bill itself is trying to address. So one could say that insofar as it relates to food law, there is already, to a certain extent, national standards in existence which are designed to fulfil the principles of the bill.
The SFELC, which is a daughter of the FSA, has been asked by the Scottish Government to assist in developing agreed standards. So what's happening here? Is the FSA overseeing the overseer, or what? I mean,
I'll just maybe explain a bit more about what SFELC actually is. The code of practice itself provides for the idea that we need to make sure that we've got consistency across the piece in Scotland. In reality, in Scotland, we're actually quite lucky insofar as we have a relatively small number of authorities compared to other parts of the country. But still, there needs to be a mechanism by which those authorities will consistently apply the community law. Just to say, first and foremost, that most of the law we're talking about here is set at a European level and is consistent anyway. You know, there's a requirement for it to be applying consistently in each member state, so that provides a backdrop for that. What SVELT does is provide a national body which gives advice to the agency on the ground enforcement matters, as it were. These are practitioners in the field. The committee has representatives both from the enforcement community, it has representation from consumers, and has representation from industry. So I guess what that committee is doing is helping to a sounding board, I guess, for the FSA to make sure that the policies that, on behalf of Scottish ministers, it's imposing are actually practical and working, which I think is actually in accordance with, you know, what the better regulation principles are.
Okay, thank you.
Dennis Robertson.
Good morning, gentlemen. Perhaps maybe refer this to George in the first instance. There seems to be general agreement around the issuing a single certificate to the street trading and sort of for the mobility of, you know, street traders moving around different authorities. However, the certificate in itself doesn't really enable, you know, mobility and trading, does it? Because you've still got to apply for a licence in the different authorities.
Well, I would have thought that the street trader's certificate of compliance would work hand in hand with any licensing provisions or requirements, in that at present, I just retired in August, so when I talk about this, it's from what happened in August. At that time, each local authority had to issue a street trader's licence, and they required a certificate from the Environmental Health of Compliance in relation to food hygiene. That was quite cumbersome, and what we would envisage is that the certificate would be issued by the home authority or the authority where the street trader was based, and that would show compliance with the actual premises, the movable premises themselves, almost a bit like an MOT. So that certificate would then go with that vehicle wherever it was operating, and there would be a confidence that the actual structure of the movable premises complied with the requirements of the legislation. That does not mean that the person operating it operates it in compliance with the legislation, which is slightly different. I mean, it may be that because Scotland is such a small place, and the local authorities tend to have good liaison, that the licence, the actual street trader's licence, can be issued on a national basis as well as the certificate of compliance, but maybe that's a step too far for.
So in reality, the street trader, regardless if they're going, say, from Aberdeen, who's maybe an issuing authority, and they're coming down to perhaps Edinburgh, they've still got to get a licence.
At the present, yes. I don't know what your thoughts are on extending that to in relation to, because that's a legal system. That's not something that I was involved in. I was only involved from the hygiene point of view. And
when we had evidence from environmental health officers, there was some, you know, discussion around perhaps lowering of standards, and that was a concern, you know, because of the issuing of the certificate in some respects. What's your view on that? I mean, basically, should we be going for the gold standard, as apparently Glasgow, Edinburgh, Aberdeen and other authorities have? But there was just a slight concern.
I don't understand that. As a practising or an ex-practising environmental health officer, the consistency required for the vehicles, they should all be meeting the same standard as laid down by the regulations. So if you're an EHO in Inverness and you're one in Edinburgh, it should still be exactly the same standard. And I think that's what this certificate of compliance would do. I don't know where they're coming from for the lowering of standards, unless they are expecting to not inspect the vehicle at all. Whereas if it was, say, an Inverness vehicle came to the Royal Highland Show in Edinburgh, the Edinburgh environmental health officers would still inspect it for the actual hygiene practices that the operator had in place, and could actually ignore the physical nature of the premises, because that had already been inspected and was in compliance with the legislation.
Rhoda Grant.
Following on from that, so therefore having the certificate of compliance doesn't mean that the street trader is not then visited by environmental health at the place where it's asking for a licence. So does this make no real difference? I mean, I suppose what I'm thinking is, if you're normally applying for a licence, you get a certificate of a compliance, the environmental health officers examine the business, issue the certificate. But what you're saying, that only covers actually the vehicle, it doesn't cover anything else.
That's what happens at the moment anyway, because the vehicle is inspected for a street trader's licence and it gets its food hygiene compliance certificate, but the environmental health officers still inspect it whilst it's trading to ensure that the food hygiene practices are actually in compliance with the law.
Not as a proviso of getting the street trader's licence?
It's a proviso.
Just as part of their day-to-day examination?
It's part of their normal working routine, just as you would do a shop. I think if you look at it in terms of similar to a large supermarket chain who will produce a building that complies with all the relevant legislation, it will produce paperwork that will put in place documentation in relation to its duties under HACCP. But it relies on the local manager to actually do it to those standards. So it's only as good as the local manager. And that's really what we're talking about here, is that you're giving a compliance certificate for the premises, but it's only as good as the person operating it when he's actually under pressure or operating on site.
What then would be the practicality, say, if somebody had a certificate of compliance issued by Aberdeen City Council, decided to go to Rockness, were examined by local Highland Council environmental health officers there, found not to be in compliance. The vehicle was maybe in compliance, but the way they were operating was not in compliance. How do they then go about revoking the certificate of compliance, or what steps can they take?
The certificate of compliance is purely on the vehicle, so if the vehicle complies, then that certificate doesn't require to be revoked. The only thing that would be revoked would be any street trader licence, if it's still being issued by individual authorities. So it would be the actual permission to trade at that time, because they'd be in breach of hygiene legislation. But in effect, what would happen is that the environmental health officer would serve notices on the hygiene practices and actually stop the operation of those unhygienic practices. That would be the practicality of it.
But if they then decided, OK, I've been stopped by environmental health officers at Rockness, I'm going to go back to Aberdeen, I have my street trader's licence in Aberdeen and I've also got my certificate of compliance, is there anything to stop them going back home and setting up shop again?
Well, normal practice in a situation like that, or at least it used to happen, is that if you found a situation like that, you would immediately notify the Home Authority that this is action that you've taken.
So there would be no added complications that would happen?
I don't think so.
Okay.
Not in my view.
Okay, thank you.
Okay, thank you. If nobody's got any questions about the mobile food regulation and licensing, I think we'll move on to the other issue of the duty on sustainable economic growth. Alison Johnson.
Thank you, Convener. I'd like to direct this question to Mr Fairgrieve, if I may. I'd just like if you could elaborate on your concerns. You raised concerns in your submission about how the proposal to place an economic duty on regulators might sit alongside other core functions and duties that the regulators already have.
I'm sorry, I'll have to check it because I didn't write this. I mean, I've always, this is a personal statement here, I've always believed that in a local authority context that first and foremost the local economic development was one of the primary things to be considered. But I think that it depends how such a thing is written. If it's a statutory duty on a specific action by a regulation, then there may be and I'm trying to envisage what Robert was thinking about when he wrote this. There may be an almost conflict of interest in that the regulation is saying one thing, but in the back of your mind you've got a duty to consider this impact, economic impact on the area. And so there may need to be some very clear guidelines. I can say that in many of the discussions that we've had in committees in that the difference in opinion on what is actually sustainable economic growth draws quite a wide range of opinions.
It certainly has done on this committee. Now, Robert raises concerns about that definition, and Robert is also surprised that if we're going to introduce a duty on regulators to contribute towards sustainable economic growth, he's surprised that why we're not introducing a duty to improve the health and well-being of people in Scotland too. Do you have any comment on that?
I think from the point of view of REHIS's main aim is to stimulate the interest and disseminate knowledge in relation to environmental health, to try and raise the standards both professionally and of the health of the British public. If you go back to the start of the old sanitary inspectors, their duty was and aim was to improve the health of the Scottish public. And I think that's really what's behind Robert's statement in that we have to be careful that we're not losing sight of why we were introduced in the first place way back in the 1890s.
Much. Thank you, Convener.
Okay. Anybody else want to come in on this point of economic growth? Mr Adamson, does the FSA have a view on this?
Yes, David, it may be useful just to say, because committee members might not be aware, but I was actually asked to give evidence to the Rural Affairs Committee on this particular part of the bill and provided some written evidence to them, which obviously I can share with you. Just to say, you know, we don't have a problem with the wording necessarily. We have, in fact, ourselves objectives in relation to our strategic plan to make sure we are trying to contribute to sustainable economic growth. Importantly, of course, there's a caveat within the section which talks about insofar as it's consistent with what the regulator's functions are, and we see that being one which makes it quite clear that if there was a public health risk, then of course that public health risk which would not be overturned by some idea that somebody could have to promote economic growth in conflict with that. Our own organisation's view is quite simple, actually. We believe that better regulation, proportionate regulation, consistent regulation, targeted regulation, in actual fact does assist in supporting economic growth, because what it does is make sure that marketplace is actually protected, and make sure that the public health is protected, public confidence is maintained, and thereby we will have sustainable economic growth. as committee members, I'm sure will be aware, in circumstances where there are food incidents, for example, then what happens is the marketplace is deflected, the public confidence is lost, and then in those circumstances you would not get sustainable economic growth. So if we can have a targeted approach which minimises the amount of food incidents that take place, then that in itself, in our view, goes a long way to indeed sustaining economic growth.
Right. If there's any other questions they want to ask, I think we can call a halt there. Thank you very much for your time. Thanks for coming in. It's very helpful to the committee. And we'll now have a short suspension. Thank you. Right, if we can reconvene, item 2 on the agenda, looking at the committee's work programme. We've had responses now in relation to the underemployment inquiry we held from a number of different bodies who've written to us. We've also, in relation to previous one-off evidence sessions, had responses in relation to follow-up points from Ofgem, Scottish Enterprise and Highlands and Islands Enterprise. These have all been circulated to members. Do members have any comments they wish to make, first of all, on the underemployment responses, or any points that they wish to see followed up? It's a very detailed and comprehensive response from the Scottish Government on a paragraph-by-paragraph basis. There's quite a lot in that, and quite a lot of ongoing issues I think we need to keep an eye on. Anything specific members want to raise? No? Happy just to note that response? Okay. And then in relation to the one-off evidence sessions, yes, Mr. Brunel.
I'm not sure whether I read recently, did Westminster did something on underemployment? Was there a ministerial statement on that comment? Can we just check that?
We can check that. I'm not aware of that myself, but we can check that out. Yeah. Okay, and then on the one-off evidence sessions, there's follow-up correspondence from Scottish Enterprise, Highlands Islands Enterprise and Ofgem. Everybody content to note that, or any points people want to follow up? Happy just to note that? Okay, thank you. Just before we move into private session, I just remind members, or let them know if they didn't know, this will be the last day we have both Jane and Catherine with us, both of whom are moving on. Jane moving back to public audit, and Catherine's moving on to Finance Committee. So I think we'd like to put on record our grateful thanks to both Jane and Catherine for all their efforts with the committee in previous weeks and months, and wish them well in their new positions. And with that, we will move into private session. Thank you very much.